Okay, so good afternoon and a very warm welcome to all the participants and our extremely learned faculties, the speakers for today. Today we have Amarjit Singh Chandhiok sir. Sir is a senior advocate and former additional Solicitor General Supreme Court of India. Sir is also the president at Maadhyam, Council for Conflict Resolution. Sir is also a member of the advisory committee of IBBI and the chairman of the working group of IBBI. Can I request sir to say a few words, initial remarks, sir?
Thank you, Nitin. Thank you, Rocky. Thank you all participants for joining in this great, I think, institution that we are building up. And we must all thank the organizers, Rocky in particular, for taking out this time to ensure how do we build an institution, which institution is today the requirement in our economic system. And as I go back to the year when we were thinking of bringing insolvency law, many of us thought there is no RP here. We had not thought about an resolution professional who will be the one. But all of you together, jointly and severally, have contributed to a jurisprudence of building up the IPR regime, which is unheard of in the world. Please take that as a proud privilege, being a resolution professional or connected with insolvency or bankruptcy. In 2012, we all know that we won the Best Jurisdictional Award, beating Singapore. And I'm sure once we bring our cross-border insolvency, etc., in place, we'll go back to those days and probably have that position. The workshop is an alternative career options for insolvency professionals. I was only thinking in terms of bringing home an argument to say that a mediator or a mediation in relation to insolvency, I take it into two-fold situation. One, that when you look at the principles of mediation, which in very great detail, my dear friend Rocky Ramesh is going to bring in, Ravinder is going to bring in, you will see that how important it is that you will find, even as a resolution professional, you will change your attitude towards your own profession. I can only share with you that in 2006, when we started this mediation movement in Delhi, we had people who were seen shouting in courts virtually when they were arguing. I see them calm down in court today. Their submissions are, their mode of making submission is different. I've seen people changing when they're writing something, instead of telling somebody that you are left, right, and center, they are very calm, composed, and with great dignity they've started writing. So all these are changes in your life which this mediation process brings in. And if you, even as a professional, as a resolution professional or a chartered accountant or a cost accountant or a company secretary, you wish to look at mediation as a career also, as I see that alternative career option. It is a career option with the need of the hour today. My experience today tells me that the conflicts started even in our schools. There are conflicts between students and teachers, between parents and school, parents and teachers. We went to the higher education institution, we found conflicts there also. There are conflicts all over the society. And if you as a resolution professional with mediation as your goal or mediation as your motto, as today Rocky has, I'm sure you will contribute to the cause of harmony, peace, and building an institution which is in need of the hour. If you go back a few years, I don't think we had thought about that an insolvency regime will come to this country, and we'll probably have a role to play in that regime. But after we saw 2016, the change, few people came forward, took up the assignments as rescue professionals. And here we see the situation coming to what we are today. Some people, in the last week, somebody is speaking somewhere in a college, in fact, a question was put to me that why is it that the Supreme Court does not look at its own judgments? And why does it put all these stumbling blocks in the path of insolvency that was already going on? So my answer was only this, that ultimately the judgment is a reflection of who appeared. Judgment is a reflection of how he assisted the court. Therefore, it is we as lawyers or anybody who appears there must take upon himself the responsibility to see that how do I contribute to the cause so that it becomes better, it becomes institutionalized, it is looking at something which will probably be leaving behind a legacy for people to adopt. Mediation is a structured process. As I said, Rocky will tell us all those details, but it's a structural process. And we brought this into our statute book. In fact, if you go back in our Vedas, etc., all these elders used to resolve disputes between the parties, between villages and everything. Then Britishers came and we changed over everything. We forgot about it. Till in 2002, we brought an amendment to the Civil Procedure Code and brought the concept back. Now, this is a structured concept, which from that day onwards has developed. And today, what we are looking at is how do we make insolvency and bankruptcy. So bankruptcy has elements of mediation there in terms of its own statutory provisions. But it's looking at now CIRB process. How do we bring and integrate mediation into it so that we can look at it, see how we can resolve matters better. The topic says pre-default, topic also says post-insolvency. The law is absolutely made clear in the recent pronouncements made. When can we do it? Pre-default, of course, whether you want to go in terms of the RBI's circular or otherwise, you have mediation professionals today available, especially in a place like NCR, place like Rocky, person who tops our list, which will help you to resolve your disputes that you have amongst your creditors, amongst your shareholders, and to see how win-win situation can be brought about for both sides to ensure that your industry, your work, your business does not in any way suffer. In fact, in a recent example that I can share with you, a question arose in relation to a undertaking being transferred by a transferor to a transferee. And two of the creditors were not willing to do so, though in terms of law, they would be bound by the majority decision. But the management thought it's best to resolve it. So the mediation came before me. We resolved that matter. And today the undertaking stands vested unto the new transferee. So this is a mode that you will have to see when the default occurs. How does, or default is likely to occur, which will prejudice you in your business. So take aid of professionals who are today doing mediation in a big way, and you will find you will be able to do this. Call them in, they will felicitate helping you to resolve that dispute so that default does not actually take place. In fact, Mr. Gupta will help us in detail to tell you, but I'm only bringing that we started capacity building now. We have recently held a training program at Manesar. We held another program which is international on cross-border mediation at Agra, where we got for the first time in this country an institution called Stouts Institute from the United States. It's all the best institute today in the world, number one on conflict resolution, to accredit our mediators who would then become mediators to work with you all. We are now looking at from 26th or 27th of April, I think, with the Singapore Mediation Center coming forward to help us to draw up a plan to look at how do we train our professionals into mediation and then they were international mediators in any conflict that you see. I'm sure we will share that details with you from Maadhyam, along with Mr. Rocky, who is here with us as a spirit holder. So what I'm suggesting you all is to see what are the ways and means, how do I adopt this structure into insolvency? How will it help me to resolve disputes or conflicts between parties at pre-default stage or post-insolvency stage? In fact, my personal view would be that why, if a resolution plan can be passed by COC with 66%, why do you need in a 12-way 90% to be consented to? I thought the same yardstick should have applied. But then that's a legislature to look at it. The 90% has been upheld by the Supreme Court. So it will not necessary for me to go into the details of that. But I'm only expressing a view that if a yardstick has been created in the statute, in the code itself, where you are allowing COC to pass a resolution for restructuring or liquidation, either case, with 66%, then why do you need 90% if the settlement is to take place with 60%? You should allow it to go through. So that what are we actually looking at? The purpose of both is what? Restructuring. Purpose of both is settlement. Purpose of both is that industry, that business is available to all of us, whether we are participating directly or indirectly. If mediation is a structured process to be utilized by all of you, I'm sure many of you will probably, I see many lawyers today, for example, who are now not looking at litigation. They are now looking at only doing mediations, and there are mediations right from the time conflicts with respect to matrimonial, Hindu law, now to commercial ventures of all kinds that we look at. In fact, a recent great example could be none else but the Supreme Court. The J1 today, Justice Sanjay called, his lordship took upon himself, called us all, made us come to meet each other outside the court, and we have been able to resolve those two of the people. One is in Canada, the other one is in New Zealand. We were able to resolve that dispute in the mediation settlement. So this would be a settlement which you will empower the parties to. So the conflict is between the debtor and the creditors. They both will be empowered by you as mediator to resolve their issues themselves. You will only felicitate doing so, help them doing so. So this is also a function which will change you in your resolution plans when you present it to the COC. It will also help you to build up relationships individually with the creditor and the debtor, to see that many times you see applications going to the adjudicating authority that the erstwhile management is not cooperating. With this process that you're looking at today, I'm sure your own handle in your hands would change for good and change for the betterment of insolvency, which we are looking at. And the training, as I've already told you, is taking place. In fact, I must confess to you that in that training, Rocky ji came forward to our aid. He helped us understand how do we bring mediation, the relationship and the relevance of mediation with insolvency and bankruptcy. And our participants really were enlightened with respect to the same. I'm sure today's event would be an event where you will take home the minimum, maximum, and the way mediation process can be adopted for insolvency, and probably will enrich ourselves with the experience of Mr. Rocky Ravindra. Thank you so much for joining us all. Thank you so much, the Institute, the organizers, and Rocky in particular, for giving me an opportunity to be part of you, to see you all, and to request you all that when I started mediation in 2006, I was very apprehensive of it. In fact, 1.5, 2 months before, I was that time the president of Delhi High Court Bar Association. The Chief Justice were asked me to take up this issue. And 2 months or 1.5 months prior to that, we started a mediation process in district court, and it was ransacked by lawyers, totally, actually ransacked. So it was a great, huge responsibility to take over. But we are happy that we took it over. And today, if you ever go to Delhi High Court, and if you can't get an opportunity, please tell me, I'll take you there. You will find 60 to 80% 80 cases listed every day before mediators for the purpose of resolution. And I'm very happy to tell you that in IPR, in many other IPR in particular, matrimonial, the success rate is 62%. In the respect to families, it is 79%. With respect to IPR, it is 85%. Therefore, I am sure when you all adopt mediation, we'll be able to make this insolvency process, which many people say, court is not doing it. We find we are stuck up in the NCLTs. All that will get resolved once you come to the conclusion that the matter can be resolved between the parties. Thank you very much. Thank you, Rocky. Thank you, organizers. Thank you, Nitin, for this opportunity. Grateful to you. Thank you.
Thank you, sir. Thank you for enlightening us with your commendable views, sir. I mean, you have just summarized the whole mediation PPT in your 10-minute talk, sir. And I am very grateful to you for giving me an opportunity to speak before the mediators, whom I could somehow give them a glimpse of the insolvency process and how it can probably be used within the sphere of mediation, and probably adjudication process can become much more faster, so that the value of the assets available to the creditors remains at a maximum value. So Nitin, should we start the presentation?
So were you calling me out?
Yeah.
So probably I didn't hear.
So let's start the presentation then. Okay.
Sure, sir. Sure.
Okay. Good afternoon, everyone. Today we will be going through a small presentation, which is prepared for insolvency professionals regarding mediation. Earlier, we had done one presentation to mediators in respect of insolvency, and that was a presentation which was focused on insolvency. Since most of you are insolvency professionals or related to the profession of insolvency, we have created this presentation to give you more insight into how the mediation process works. So this presentation would be fairly long. It's not a short presentation, like I said, but it would be fairly long. But yes, it would be keeping the total mediation aspect within how it is to be used within the insolvency framework, and that would be used as a preventive or as a curative tool, as Chandhiok Saab said, that it could be used pre-default or in a pre-insolvency stage as a preventive measure, and as a curative measure within the process of insolvency, within the CRP process. As you all know, the disputes in an insolvency all are about money. In situation where the debtor faces financial problems and creditors want a return of their money, the first course of action by any stakeholder, the creditors, often is to initiate formal insolvency against the debtor. The resolution of insolvency dispute has long been limited to the courts. A well-functioning insolvency regime can be a powerful tool to promote entrepreneurship, access to finance, innovation, and economic growth. It is no secret that insolvency litigation is time-consuming. I guess everybody would agree with this, at least in context of Indian adjudication processes in insolvency. These many times results in liquidation and consequently results in closure of businesses, along with loss of jobs and tax payments or tax revenue for the state. Loss of businesses for the vendors and other connected businesses in the supply chain consequently affect the economy. We have seen this in, actually, I personally have seen this in Bhushan Steel case, where a lot of vendors of Bhushan Steel went into insolvency. Mostly the distribution of proceeds in sale or liquidation is only enough to cover the secured creditors, and the residuary stakeholders are left with nothing of substantial value. When we speak about settling of disputes or conflicts, we have other choices as well, other than the court adjudication processes. We are talking about the alternate dispute resolutions, and mediation is one of that ADR process. In mediation, the parties try to resolve the disputes with the help of a neutral. Now, a mediator is a person who is a neutral. He has no conflict of interest with the parties, and he's supposed to act completely as a neutral. A third party facilitator, he's a third party facilitator who's called a mediator as well as a neutral. So when we talk about a neutral or a mediator, it's a common term for both. Unlike an arbitrator or a judge, a mediator does not render a decision in the dispute. I'll be explaining more on this as we go along in the presentation. The goal in mediation is to negotiate and reach a settlement voluntarily through a process. Like Chandhiok Saab said, it is a structured process. The mediation process involves reality testing, risk assessment, and the main emphasis is to encourage negotiation, finding creative solutions, and compromise. Alternate dispute resolution in its literal meaning is a settlement of disputes outside the court. But this settlement is not is a supplement to the court system. It's not something which can always be done outside the court, and it's a separate sort of a dispute resolution system. It is always be supplementing the court resolution system for a quick and affordable justice to litigants. No, Chandhiok Saab has told you a lot about the history in some sentences, but in India, when we talk about law, it is Mullah's Hindu law, which we basically go to in case of some sort of a jurisprudence. So this, and in India, Vedas have actually brought out the law on substantive law, procedural law, and that has been used in the current statutes which are available in India. The early Aryans around 10,000 or 4,000 BC before were very vigorous and unsophisticated people full of life, and behind them ages of civilized existence. They primarily invoked the unwritten law of divine wisdom, reason, and prudence. And this wisdom, reason, and prudence became the originating philosophy of mediation. Hindu law is also known as dharma, which means righteousness, duty, and law, which applies to everyone. And it consists of truthfulness, non-injury, and generosity, among other virtues. So within the Vedas, within the Simritis, and within the Acharas, we find a lot of complex laws which are defined in a very simple way. As societies grew in size and complexity, informal decision-making processes become more and more structured and gradually took the shape of formal justice delivery system. In societies which could not grow larger in size, complexities without first involving a system resolving disputes, they could not keep pace with the society and the harmony and the peace. And a society where we have a history of more than 4,000 years, this has developed very well in India, as we have seen. If we talk about the Mughal period, we talk about Birbal, who was the Akbar's go-to man for complicated issues. One story that I would like to tell you is about, which I always tell when we take up these sessions of mediation, is that Birbal, Akbar was faced with a problem when two ladies came to him and stated that the child they have got in front of them, and both the ladies were claiming to be the mothers of that child. So Akbar told Birbal to sort out this issue, because this is something at that point in time, probably DNA was not available. So he told Birbal to please sort this matter out. So Birbal asked those women, what do you want? So both the women were saying that this child is mine. So Birbal said, let's cut the child in half, and half could be given to one mother and the half could be given to the other mother. What happened? The actual mother started crying and said, please don't cut the child. give this child to the other woman. She is the mother of that child. At that point in time, Birbal knew who the mother was. And this was one of the first mediations probably that took place in Akbar's court. During the British period, there was a Bengal Resolution Act of 1793, and thereafter the Indian Arbitration Act 1899 was introduced, and thereafter Arbitration Act of 1940, and post that, the current Arbitration and Conciliation Act 1996 was legislated. Now, Abraham Lincoln said something: discourage litigation, persuade your neighbors to compromise whenever you can. By neighbors, he doesn't means all the disputants. Point out to them how the normal winner is often the real loser in terms of fees to the lawyers, expenses, and waste of time. And then he had a word of advice for lawyers as well. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough. So like Chandhiok Saab said that when he was setting up the mediation center, a lot of lawyers barged in and probably created a huge ruckus because they probably thought that mediations would take away their livelihood, which is not actually the fact. Rather, it would supplement their means of earning if they take up mediation, and it would be good for the parties as well as the lawyers. Now, Joseph Greinbaum is a mediator. He's still present, active, and the words he said make a lot of sense in the current scenarios. An ounce of mediation is worth pound of arbitration and a ton of litigation. If you go back, that mediation can help sort out the matters much more easier, much more cost effective in a timely manner, rather than the two other ways of getting justice is arbitration and litigation. So that is how important mediation is, and it is not being used to its fullest extent in India. So let's talk about mediation in insolvency. How did it begin and how was the result of using mediation in insolvency? It all started in 1986 in the United States. This court was the bankruptcy courts of Southern District of California. They initially established the mediation program. This mediation program was used in the United States at the first instance in Greyhound Lines Incorporated. This is the name of the company in which, or the case in which the mediation was first used. Greyhound went bankrupt and set up a pre-reorganization mediation plans for a lot of thousands of claimants who had brought personal injury and property damage claim against the company in connection with traffic accidents involving Greyhound vehicles. And Greyhound is a company in the US which has a fleet of buses and passenger vehicles transporting people from one place to another. This case was a very good example of multi-party dispute resolution in which the debtors dealt directly with each of the creditor. The ADR procedure in Greyhound dispute consists of 3 separate specific stages. In the first instance, the first stage, the creditor had to complete a claim form for lost wages. So if anyone who has got hurt by a Greyhound bus or any vehicle, he would have been injured and he would have been transported to a hospital, given first aid, and then sent off home, and then he would have lost wages. So they were supposed to complete a claim form for lost wages, medical bills, and other damages. In the second instance, the parties negotiated the damages. And if the creditor refused to participate in this stage or a final decision was not reached, the parties engaged in mediation for another 60 days. If the parties failed to reach an agreement, they had recourse to arbitration. You would be amazed to know that half of the claims were resolved in the first stage. And we're talking of thousands, hundreds of claims. This is an example of a win-win situation and win-win negotiation, which made it possible to resolve the cases promptly. It avoided adjudication in the court process and litigation costs. When we talk about mediation, the next case that comes to our mind, and which is very important case, is Lehman Brothers. Lehman Brothers was an investment bank in the United States, and 2008, Lehman Brothers went down into insolvency. There was staggering debt of almost 760 billion plus of debt, which was covered by an asset worth of $640 billion asset. There were insolvency proceedings on almost 16 plus jurisdictions worldwide and thousands of cases. Despite that, hundreds of unsecured creditors, those whose debts were not guaranteed by the assets, were repaid between 20 to 40 cents on a dollar. US bankruptcy court permitted Lehman Brothers to undergo non-binding mediation with its creditors, which allowed the firm to collect on debts owed to repay some unsecured debtors. And if we talk about the amount of litigation costs saved in Lehman Brothers, is upward of $5 billion. And that's a huge amount that we're talking about. It might be, say, 8% of the total debt, but it is a huge amount. In terms of the European jurisdiction, the EU jurisdiction, the current directive on insolvency restructuring and second chance is also favoring mediation as one of the dispute redressal system within the insolvency regime. Mediation has different meanings across jurisdictions and cultures. Its common feature is the lack of authority. The mediator does not have any authority to force the parties into a settlement agreement. Parties have to choose a neutral to conciliate the differences, aiming for a win-win outcome. The mediator encourages the parties to look beyond their disputes and focus on the settlement ahead. The mediator's role to assist the parties is manifold. Firstly, separating the personalities from the issues, removing obstacles to communication. I'll be coming to all these when we go further in the presentation, but yes, communication is the way to go in any sort of a conflict or a dispute. On Friday, when I was taking another session on turnaround, I just gave an example that if I have given a debt to Chandhiok Saab and Chandhiok Saab calls me up to get his money back from me, probably if I am in a very bad situation, I'll not pick up his call. Then Mr. Chandhiok would say, yes, this person is a thief, he is not ready to pay back my money. So that is the mindset that comes up when there is lack of communication. However, what if I tell Mr. Chandhiok, sir, I don't have the money today, I might have the money 3 days later, so please wait for 6 days and I'll give you back your money. That instills a sense of confidence in the other person that, yes, this person is communicating, telling me something which is probably a genuine thing, a genuine issue with him, so he will give that money back to him. So that communication has to be there. And most of the debtors and the creditors, because most of the creditors are banks, most of the debtors that I've seen and that they have come to me, they stop communicating with the banks. This creates a situation of mistrust, which goes further ahead and create problems for the debtor. So to mitigate all this, communication is a very main issue in any sort of a situation in insolvency. And in mediation as well, this is a common factor that mediation encourages communication. And the third option is the suggesting and exploring various creative settlement options. Now, I'll give you an example on that. So there was a mother with 2 kids, and there was one orange, right? And both the kids wanted that orange. So mother said, okay, you take half, and the other boy would take half, and they refused. They said, we want, both the boys were saying, we want the full orange. Probably you don't give one to this guy, give it to the other person, the other boy. Now tell me, how will you try and get to the core of this issue of a mother? Then there is one orange. There's only one orange, and both the boys are asking for it. So how do you settle this issue? Can anybody tell me about this? How do you settle this issue? Communication. Communication is the issue here. So the mother took the boys, each boy, to another room. First, she took the first boy to the other room, and she asked him, why do you want one orange? Why not settling for half an orange? So he said, Mom, I want to eat the whole of the orange. The orange pulp, I need the whole. I just want to do that. Okay, she said. Then she took the other boy to another room. Said, what do you want? You also want the pulp? He said, I don't want the pulp. I want the peel. So why do you want the peel? Everybody, when we were kids, we used to use the peel to press the peel and get the juices into the person's eyes. So he wanted that, matter salt. Mother peeled the orange, gave the peel to one boy and the pulp to the other boy, matter was resolved. So this is what mediation is all about. Now I'm going to show you one video which is going to explain a lot of things to you, because we are in a virtual way of communicating as of now. So if it would have been a physical, we would have done it, I mean, in a physical way, but since we are virtual, so I'm just going to show you a video, but I don't know whether the audio would reach to you or not. Let me see.
In this video, we discuss mediation. Mediation is a process. In this mediation. Mediation is a process where in this video.
Can you hear this?
So we can hear it.
We will
Okay,
discuss
okay.
mediation. Mediation is a process where a neutral party assists in negotiations. Let's say we have Patty and David, and they have a contract. Patty thinks that David broke the contract, and David says that Patty breached the contract. Now they could go to court, but litigation in the United States often takes a long time. Also, sometimes it can cost a lot of money. Also, it's public. Other people are going to know about it. So maybe Patty and David will decide that they don't want to go to court right now. But what else can they do? They could try to negotiate and settle their differences. And maybe they try to have a discussion. But their negotiations might not go well. Now let's say they bring in a neutral party, Mary, to help them negotiate. Mary will work with Patty and David to help them negotiate. By assisting in negotiations, Mary is a mediator. A mediator helps parties negotiate to resolve their disputes. But a mediator can't force parties to resolve their dispute. Nor does a mediator decide who should win the case. But by going to a mediation, the parties are choosing, for now, not to go to court. The mediator will talk to Patty and David together about the dispute. She'll probably also talk to David privately, and she'll probably also talk to Patty privately. The discussions in a mediation are generally confidential. They're kept secret. If the mediation is successful, the parties will reach an agreement. The parties will probably write down and sign their agreement in a settlement agreement. For example, the parties might agree that David will pay $75 and the dispute is over. But let's say David refuses to pay. Now Patty will probably have to go to court. And the judge will probably enforce the settlement agreement. He'll make David pay. Sometimes courts will force parties to try mediation. This is usually called a court-ordered mediation. But no one can force the parties to settle the dispute if the mediation is unsuccessful. The parties will report to the court that the mediation was unsuccessful, and the case will continue in court.
Could you hear the audio in that video?
Yes, sir, we could.
Okay. So like Chandhiok Sahab said, mediation is a structured process. If you go back to any instance in your life where where there was a dispute of some sort, say a matrimonial dispute in the family, and it could not be resolved by the parties involved, what happens normally is that whosoever has got that arrangement of marriage done, those people are called, or elders in the family are called to settle those disputes. Whatever they say probably is acceptable to all the parties, because there is a trust level, there is a level of respect with those people, and people understand that what the mediators, so-called mediators, are saying would be to the best of the ways that things can be resolved. Now, this is something which is an unstructured process. However, when we talk about mediation, has become a very, very structured process, where a neutral person uses specialized communication and negotiation techniques to sort out the matters between the disputants. It is a process of facilitating parties in resolving their disputes. Like you saw in the video, they were the mediator does not imposes his will upon the parties or the disputants. He only communicates with them. He tries to get them to a common ground and then probably settle the disputes. It is a settlement process whereby disputing parties arrive at a mutually acceptable agreement. Now, what do you mean by mutually acceptable agreement? Both of them agree to a certain conditions of the settlement agreement. So if both the parties are accepting and agreeing to some terms and conditions of an agreement, what happens? Both of them are agreements on certain things which we could not agree within a formal court process. So if we agree in an informal process like mediation, which has become a formal process now these days, so that would be a win-win situation for both the parties. And we'll see how these process of mediation and the process of adjudication by the court are different. We'll get to the differences between them. So like you saw in the video, it's a voluntary process. It is a binding process. It is a binding process after the settlement has been reached. But prior to settlement, it is not binding. Parties can walk away at any point in time during the mediation process, but prior to the settlement agreement being signed. In it, the impartial and neutral mediator facilitates disputing parties in reaching a settlement, and the mediator does not impose a solution, but creates a conducive environment by using communication skills in which disputing parties can resolve their disputes. And the operating word is can. It does not always result in a settlement. It might result in parties walking away, but there's a good chance of parties settling the disputes if they are honest about it. Essentials of a mediation: it's impartial, it's confidential. Impartial in the sense that mediator does not take is not an adjudicator. He only helps parties to reach a solution, so it is impartial. It is confidential. When we talk about confidentiality, confidentiality plays a bigger role in mediation. So when two parties are before a mediator and they are talking about their disputes, the mediator can take them one-on-one as well. It's called a caucus, where the mediator gets into a communication mode with the single party itself, without the other party being present in that mediation room. That is called a caucus, or a communication with one party. So if that one party tells anything to the mediator and tells him that this is confidential, mediator is bound by that, is not supposed to convey that to the second party, which is outside that room. And the confidentiality also comes out of the settlement agreement. The settlement agreement can only be taken to the court by a party for execution purposes, that the other party is not executing the settlement agreement in mediation. They cannot challenge the settlement agreement in any court of law. It's self-determination. Like I said, the mediator is not an adjudicator. He only helps parties communicate and reach a settlement. So it is self-determined by the parties. There is a process attached to a mediation. Parties can speak in an informal environment with the power to choose the outcome. They have the choice whether to go for a settlement or not to go for a settlement. And the best part of mediation is that it can be used outside and inside the litigation process. So if you are in the court, you can go for mediation. If you are not yet in the court, you still can go for mediation. So this is how the mediation process works. In the first instance, when the mediator is in front of both the parties, he will introduce himself to the parties and explain the mediation process and stress upon and establish his neutrality. He will explain he has no conflict of interest with any of the parties, he has no relationship with other parties. He explains the ground rules. So the ground rules are also set, that when a person is supposed to speak or not to speak, when he is going to initiate the confidential process of dispute resolution. Then there is a joint session where both the parties are in front of the mediator in a single room, and they talk about their facts, the backgrounds, and the interests of the parties. He starts the interaction or a communication with them so that they are in a very comfortable mode, and they are more empowered to come out with the communications, some sort of factual positions, some sort of interests other than their positions, and create a suitable environment for an amicable settlement. Now, when we talk about the positions and the interest, these are two different things. In the example that I gave you of orange, the position of both the boys were to have the orange, right? Positions are right-based. I have a right to this orange because this room is mine, right? Whereas interests are not right-based. The interest of both the boys were completely different. So the mediator has to get to the crux of the interest of the parties and then resolve the issues. I explained to you the caucus. When it becomes necessary, a mediator allows the disputing party to further explain their grievances, continues to gather information, persuades individual parties to share confidential information, and helps them to create options for an amicable settlement. So caucus is where he actually comes to know about the interests of the parties. This is very important to settle a dispute, because egos, emotions are positions of the parties, not the interest. The interest would be something else. So when everything is settled, the mediator confirms and clarifies the terms of settlement. It reduces the settlement into clear, complete, concise, and a binding agreement, which cannot be challenged in any court of law except by way of asking the court for execution of that particular agreement. Any questions on the mediation process till now? Anyone?
Participants?
Okay, we go further. So this is the comparison between mediation and court adjudication. When we talk about mediation, there is a lot of compromise. So, whereas if we compare it to court adjudication, there cannot be any compromise, because we are fighting on our rights. There cannot be compromise on rights. In mediation process, adjudicator helps in communicating and deciding rules. Whereas in courts, we already have preset procedural and substantive laws. When you talk about substantive laws, it's a family matter, it's a Hindu family matter, it would be governed by the Hindu Marriage Act. And if it is rules, it could be governed by CRPC 125 or any other processes, any other substantive rules that there are. Party-to-party communication is there in mediation, whereas when in the court, parties cannot talk to each other, they have to address the court. Their lawyers have to address the court, not to the other party. Party is always in control in mediation. Nothing happens without the consent of the parties, which we have already explained to you and you've seen in that small video. Whereas all control is given to a stranger. That stranger could be a adjudicating officer or a lawyer. Inquiry into the preservation of relationships is the main aspect of mediation, where they look at your interest rather than your positions. Whereas in court adjudication, inquiry into relationships are completely irrelevant because of certain reasons, which are going to come in the next slide. The broad relevance focus on interest, value, goals, aspiration, and relationships is there in mediation. Whereas in court adjudication, it is not a very relevant fact about the interest, values, and goals. Mediation talks about that once there is a win-win situation between the parties, when there is a settlement agreement between the parties, they would further take up the relationship to a different level. The future relationships are going to be good. Whereas the court adjudication process works back in a backward sense, that the application of rules and laws are only to the acts which are already have taken place, not to the future acts. Cultural factors are important. Whereas when we're talking about the last slide on the broad relevance of interest, value, goal, and aspirations, the cultural factors, all those things, the value, aspiration, the interest are important. Wherein, as if we talk about the court processes, facts are very important. Emotions are not there. If anybody is a student of law, drafting should not include any emotional aspect. That I like this person is not is an emotional thing which should not be actually written in any sort of a pleading. And the factual content and only the context in that specific sphere of facts is seen. The differences, the values, and misunderstandings between the parties are massaged out in the mediation, whereas the adjudicating officer determines what the value is going to be. So value in terms of the value in terms of money, or value in terms of other than anything on money can be compromised in mediation. Whereas when we talk about the court processes, the values are there. Whatever prayer that we have asked for in a suit for amount of damages, that value is determined by the court or the adjudicating officer. Mediation process is very flexible. It is short. It can be managed. So for example, if you are late in a mediation, probably you can call up the mediator and the other party and say, let's fix up another date. Whereas in court, it's one size fits all disputes. You cannot ask for an adjournment. If probably you are asked for a couple of adjournments, you can be liable for some cost which the court can determine. The law is determined, applied, or disregarded by the parties. So it is not a question of law that is essential in a mediation. It is the question of your interest that is essential. Whereas in court, law is the supreme in terms of getting you the resolution. The facts are determined, compromised, or disregarded by the parties depending upon the consent of the parties. Whereas facts are essential, law is determined and is based upon evidence. So this is the this is the process of the court, facts, law, evidence, and then the judgment is going to come. Whereas this is not the case in mediation. So mediation, if we see, is a very, very soft process where parties are in command. They can determine their rules. They can look at various means and ways to settle the disputes in a short time at a lesser cost. So why mediation? Why not arbitration or a court-driven process? So when we spoke about a ounce of mediation and kilos of arbitration and tons of litigation, that is what we're talking about here. It's so mediation is a process where we can actually determine, the parties can determine what's going to happen. So, and this is through an impartial third party who's a neutral. Like I said, mediation is voluntary. We'll be coming more on the voluntary and the court mandated part in the next slides. Because there are two schools of thoughts. And one of the school of thought says that since mediation is voluntary, why should the court force it upon the litigants? So we'll come to that. Atmosphere is informal. All parties have their say, and the parties maintain future relationships. I'm just repeating what we have said in the earlier slides. Avoid unfavorable judgments. So if you are unable to settle a dispute, you can always walk out of it, no questions asked. And parties can walk away from at any point in time. So the benefits of mediation is the expenses that you incur in litigation are quite high. In mediation, they are substantially less. Pardon?
Yes, sir. File तो मेरे पास है.
Mr. Mishra, I think you have to put yourself on mute. The process of mediation is speedy, and what I have seen is that most of the disputes can be settled in 4 to 5 sittings maximum. For complex disputes, this could be higher, but yes, for a normal disputes, 4 to 5 sittings, the matter can be sorted out. There is fair hearing and participation. Parties power to tell their own stories in detail. In courts, you can't do that. Whatever you have pleaded, only that you can talk about. You cannot talk about emotions. You need to talk about only facts which are provable. Discovery. Now, this is something which doesn't happen in a court process. Discovery of interest. Why this party was having some sort of issue with me. So there was an underlying interest which can come out during the mediation process. Solution based is the effective marker of mediation, that yes, like Chandhiok Sahab gave you the statistics, 69% in some disputes and 72% in some disputes. That's a high percentage of settlement where both the parties feel are in a win-win situation. So that doesn't happen in a court case, because in a court case there always would be a winner and there would always be a loser. But here in mediation, it's a win-win for all. Once the settlement agreement is reached and it is executed, there would always be peace of mind for both the parties. Both the parties would be happy. They would continue the relationship, and they would not be a loser in the whole process. Again, this is a repetition of settlement mediation. There is no winner or loser. The agreed settlement is sent back to the court for its execution. The entire process of mediation is also time bound, and it saves both time and money of the parties by providing quick and affordable remedy to the parties with their consent and dispose of disputes comfortably. So why I'm repeating this is that it should be ingrained in your mind what the mediation process is, because once you know about the mediation process, only then you can apply it to an insolvency proceedings, where we'll be taking you through the next slides. And we'll take you to the next slide now. Now, legislative intervention globally. So when we talk about legislative intervention globally, there are a lot of things that we need to talk about. Mediation can be used in a pre and a post insolvency situation. That is, if we talk about it in Indian terms, we can say that it can be used within a CRP. It can be used prior to filing of an insolvency case. It can be used prior to admission of an insolvency case. It can be used even till the COC is formed. 25th or 26th, the COC is formed. So before that day, before that T25 or T26, mediation can be used. And if you come down to pre-filing, it could be at a pre-default stage as well, that mediation can be used and stop the company from getting into an insolvency. The second thing that we need to understand is about the voluntary nature of insolvency, voluntary or court mandated. So there are some jurisdictions like Hong Kong, Singapore, and England. In the courts in these jurisdictions do not compel the parties to mediate. There was a very interesting case in England in 2004, Halsey versus Milton. The courts held that this is the Court of Appeals held that the courts do not have the power to order parties to submit their disputes to mediation. That is what the appellate court said on the power of courts to send the parties to mediation. This is, I'm talking about 2004. In 2008, Lord Phillips expressed his doubt about the Halsey versus Milton judgment. And in his extrajudicial speech before the Parliament of UK, he said, and mind my words, he said, you can take a horse to water, but you cannot make it drink. Meaning, now I'm not quoting him, I'm just telling what this line says, that you can take the parties to mediation, but you can't make them mediate. This is what he meant when he said, you can take a horse to water, but you cannot make it drink. But in the next line, he says, the horse usually does drink when it is taken to the water. That means that unless people have a flavor, understand the flavor of mediation, how are they going to be understanding its use, its benefits? Whereas Australian courts are empowered statutorily at the federal and state level to court-ordered mediation. In US, there is no statute regarding mediation, regarding the court-mandated mediation or a voluntary mediation. But the courts are now going for mediation within an insolvency process, within the Chapter 11 filings. Now, there are 2-3 things that we need to be very careful, and we should be using these principles of putting the cases of insolvency in mediation, which a lot of appellate courts in US have taken care of. Some certain principles which need to be applied to a mediation in insolvency. One of the judgments of a Second Circuit Court was that parties to participate in mediation, if the courts are convinced, only the parties can participate in the mediation if the courts are convinced that the case before the court is appropriate for mediation and there are sufficient procedural and substantive safeguards to ensure fairness to all the parties. Secondly, the limiting the power to ADR process such as mediation with the parties' substantive rights should remain unaffected. That means that mediation, till the time a settlement is reached, they should not affect their substantive rights. Then, the first Court of Appeals in Atlantic Pipe Corporation have led to 3 safeguards which are completely uncontroversial and seek to protect the party's substantive interest while the mediation is ongoing. The court order must make it clear that participation in the mediation will not be taken as waiver of any litigation position. That I'm not waiving my right to litigate. The order needs to set limits on duration of the mediation and the expense associated therewith. So the time boundness of a mediation process and the expense related to the mediation process needs to be taken prior to mediation. In appropriate case,
Participants, give us some time. I'm trying to reconnect with the speaker, and then we'll probably be on course. Thank you.
Am I audible?
So we can see your video, but probably there's a problem with the voice.
Is the voice audible now?
Yes, yes, it is far better, sir. Clear, sir.
Okay, let me just start the PPT once again. Nathan, am I audible now?
Yes, sir.
Okay.
And we can
So-
see your presentation also, sir. Thank you.
Okay. So I was talking about the pre-insolvency. We have already finished the post-insolvency as far as legislative internationally, internationally what is happening in the post-insolvency front. Whereas when we're talking about the pre-insolvency, there are a lot of jurisdictions who are working big time on their pre-insolvency frameworks through mediation, and the important one being the France. France is one of the foremost countries in EU to start mediation in pre-insolvency. Then we are talking about Spain. There's a huge quantum jump that they have taken in their pre-insolvency. They brought out a new insolvency law in Spain, which actually takes care of pre-insolvency using mediation. Then when we talk about Japan, it recognizes formal mediation as a tool for pre-insolvency proceedings. In 2007, Japan established an out-of-court workout scheme called Turnaround ADR. Now, that is a very successful scheme in Japan for MSMEs. Then we have in Thailand, we have a court-annexed mediation program. And this mediation program started in 1999 in wake of the Asian financial crisis. If we talk about Africa, where the insolvency laws are not very well developed, we are talking about a pre-insolvency procedure which was passed in 2016, and mediators drive this process. I mean, there's nothing other than mediators who are using this, but mediators are
Again, there is a break. We lost you. Nitin, could you please look into it?
Am I audible now?
Yes, sir.
I'll stop my video, probably that would help because I'm on a different system now. So when we talk about various countries in which pre-insolvency mediation processes are functioning very well, there's a huge lot of them, and the simple reason for them is that nobody wants a lot of companies to get into insolvency. Like I said in my turnaround presentation, that Mr. Sahu has said that it should be the IBC process should be used as a last resort, not in the first instance. So this is where we need to focus upon in India as well. Now, various jurisdictions would require various objectives to create mediation as an alternative for adjudication. An alternative, I would not say an alternative, but a supplementary adjudication process for within insolvency. So when we talk about US, there were a lot of big insolvencies in which these were used. So the process originated from there to help out big insolvencies get faster resolution in a small frame of time. Many jurisdictions are looking at reduction of costs, whereas in India, we should be looking at fast forwarding the resolution process. As an IP, all of you know that the adjudication process is what is hampering the IBC code, the resolution within the IBC code. The value of assets is going down due to the time frames which are extending beyond what is statutorily mandated within the IBC process of 330 days, 180, 270, and 330 days. So to get over with these timing issues, mediation is very essential because, like I said, 4 to 5 meetings, it should be resolved. In terms of mediators, well versed in insolvency laws, that is one area of capacity building where mediators who are certified mediators who can be trained in insolvency laws. And the second part would be where insolvency professionals who can be trained as mediators to start this process of mediation within the insolvency processes or outside before even the pre-default happens. Now, how do we go about it? This is one thing that we'll be taking up next. Before even we start talking about how to go about the insolvency process, let's take a look at various stakeholders within an insolvency process. Because some of these would also be available to outside the IBC, the CRP, and before the pre-insolvency or before the pre-filing of insolvency petition. Creditors, operational creditors, obviously the debtor. Then we have a COC, adjudicating authority, workmen and employees. I'm putting workmen and employees other than the operational creditors because a lot of workmen and employees have different issues which can be mediated separately. And then the fulcrum of all these is the insolvency profession, who is responsible for putting process into final shape. His working is important. Insolvency principles talk about a collective process. Time is of being of essence. Maximization of value of assets. Then there is a going concern concept that the business or the company should be preferably kept as a going concern, not to be liquidated, and the best use of debtor's asset. Everything in this relies upon the second principle, that is time is of essence. We'll also look at the mediation principles a bit later. But these are the insolvency timelines. When we start from T1, from the insolvency commencement date, and go on to T330, where the statutory mandated timeline finishes. To cater to these timelines, everybody would agree with me that it is not only the insolvency professional or the COC or the adjudicating authority which is responsible for not following this T330 timeline. Yes, because everybody is involved in this. Adjudicating authorities involved in terms of not passing fast. Insolvency professional probably would be, or the COC, or the financial creditors, or the operational creditors, putting in unnecessary applications before the authority, which could actually be bilaterally managed through mediation. If, for example, if there are 10 disputes which are pending before the adjudicating authority, and if 5 or 6 of them can be mediated successfully bilaterally between the parties involved, what do you think would happen? Out of 10, either 5 or 6 is reduced, they are only left with 4 or 5, and adjudicating authority can pass an order or a judgment 5 or 6 disputes in a lesser amount of time, thus reducing the timelines. So this is what we're talking, how mediation can help the insolvency process in terms of decreasing the timelines. Once the timelines are reduced, the value of the assets would also be increased. It would increase proportionality with reduction of timelines, and it would the assets of the debtor can also be best used, because more the timeline is there, assets are not being adjudicated upon, the value of the reduction in value of the asset is taking place. Now, where can we use mediation in insolvency? Needs a lot of consideration from all of you, and you can also pitch in at any time to tell me where we can actually use mediation in insolvency. There's a huge scope of using mediation beneficially in both the stages of pre-insolvency and post-insolvency. The first thing that I can see is a pre-insolvency stage. Specifically, I would prefer, and it's my own personal opinion, it's nothing to do with any discussion paper or anything, but it is, or with any other person, it is my specific opinion that mediation may be attempted prior to commencement of formal proceedings, specifically in Section 9 proceedings, because Section 9 proceedings are bilateral in nature, that an operational creditor has a dispute with a corporate debtor. So if these two can settle the disputes, probably that would be the best option, not even to go to the court. And mind you that most of the Section 9 proceedings which are initiated in the court get settled, majority of them. So that time which is spent by the court settling those matters under Section 9, they can be done prior to that. If it becomes mandatory as per Section 12A of the Commercial Courts Act, that a mediation is mandatory, mediation needs to be done before a petition can be filed. On something of those lines, if something can be done on Section 9, at least the basic Section 9, probably there would be lesser disputes for the court to adjudicate. As per the available latest data till December 2022, 23,417 application for initiation of CRP debtor having an underlying default of over 7,95,000 crores were resolved after filing of application, but before their admission. See the number of disputes. Even after that, 846 cases have been closed on appeal or review or settled, and further 740 cases have been withdrawn under Section 12A. Show that there's ample scope for using mediation for settling the disputes. The next is the pre-packaged, pre-arranged resolution process and pre-default resolution. Like I was talking about, what is happening in the jurisdiction of Spain and France, where mediators help the debtors in preparation of a resolution plan in their out-of-court mediation mechanism. So the job of an IP has gone to a mediator. So it becomes all the more important for you people to be trained, professionally trained as a mediator, so that you can take these jobs or the specialized mediation work when it comes to fore in terms of some sort of substantive legislation, like the mediation bill is pending before the parliament, or something in lines of mediation specifically inbuilt into the IBC code. The prudential framework for resolution of stressed assets, the June 7 RBI circular. For the, or I mean, this can be a basis on which mediation can be done between a debtor and a creditor using the prudential framework, the June 7 circular of RBI. Or for the preparation of base resolution plan under the pre-pack resolution framework for MSMEs. So mediations, the mediator, who probably could also be an IP, would be in a better situation or a better position to get a win-win situation for both the debtor and a creditor. And if that happens, there would be a lot of more pre-packs than we are seeing as of today. I think the number of admitted pre-packs is two. Two pre-packs have been admitted till date since last year. Mediators can also assist the corporate debtor and creditors in negotiating and developing a mutually agreeable strategy for resolution. So when we talk about a pre-insolvency framework or a pre-packaged framework, the communication between the debtor and the creditor is not there. So who is going to initiate? IP is in a conflicting mode. So the mediator, with the skills of a mediator and the communication skills of a mediator, help negotiate between corporate debtor and the creditor to develop a resolution plan. And this is one area which I think is going to be niche in next some months when some sort of mediation starts in pre-packaged insolvency. Any comments on that? Anyone wants to add on to it? Then we're talking about claims mediation. Large number of disputes before the adjudicating authority pertains to the dispute management. The court does not recognize that a RP can adjudicate upon claims. He can only verify, admit, and reject such claims. And as such, aggrieved parties are left with an only option to pursue the matter before adjudicating authority. And in cases where the claims are huge in terms of like a real estate corporate debtor or some in any matter where the number of financial creditors or the operational creditors is very high, mediation can be a viable option for such aggrieved parties. It can be used to address the following issues: dispute relating to quantum of claims, dispute relating to classification of creditors, and the dispute relating to priorities in security interest. I guess I don't have to explain these to you: the dispute relating to quantum of claims, dispute relating to classification of creditors, and dispute relating to priority in security interests. For when I was training, giving a training program to the mediators, I had to explain everything, but I don't think I need to explain these to you. Then there would be intercreditors disputes.
One small doubt here. Can I?
Yeah.
When we say that claims can be, I mean, mediation can also be useful in claim, can IRP or RP of that in the CIRP process, he can act as a mediator, or do we need to take the role of other IP to act as a mediator?
Yes, this is a very good question. A lot of people have been asking me this question. When an IP takes the role of a mediator, as such, IP is supposed to be neutral, right? He's neither representing the creditor, he's neither representing the debtor, he's just following a process. But yes, when the IP takes over a role of a mediator, then the conflict of interest might arise at any point in time, number one. Number two, as per law, he's not capable of verifying, admitting, or rejecting a claim, right? So it brings in a neutral third party as a mediator to do all this. Now, the neutral or mediator who is not a part of that whole process, doesn't have any sort of a conflict with any of the used, because he is then positioning himself as adjudicate in place of adjudicating authority. That dispute is going to mediation, and he's going to adjudicate upon them. Then the IP is saved from that adjudicating person who is a mediator, because IP doesn't have adjudicating powers. So probably if some act allows it, that's fine, but that at this point in time, a third party mediator would be a better option.
Sir, but does it not add on to the cost? I mean, again, IRP or RP need to.
Ma'am, okay, tell me, what is the cost of a mediator per month?
Sorry, sir, I have no clue on this. Sorry.
No, say it would be minimum 1.5 lakhs. That is mandated by the statute now.
Okay.
Right? So if it is 1.5 lakhs, that is, and add on to it the litigation cost. If you're going to a court, so the cost of the lawyer and the cost of filing and the expenses related thereto would be added on to that cost. Secondly, there would be a cost of conflict. So if an application for admission of a claim or for regarding the quantum of claims is before an authority, adjudicating authority, and it sits on it for 5 months, what would be the cost of conflict in that case? That would be 5 months of time running around, litigation cost attributed to IP when he's actually in the court. Sometimes the court sits at 10:30 and then gets up at 4 and the matter is not taken up. It is carried forward or adjourned to some other day. So the cost of conflict keeps on rising, where the mediation cost is very less as compared to the cost of conflict. Then we were talking about the intercreditor disputes. These disputes may manifest themselves mostly in cases relating to distribution under resolution plan, with dissenting creditors wanting different terms from the plan. These issues may be settled amicably through mediation, saving time and cost of all stakeholders. So this is one area. So if you have a dispute within the COC, for example, right, and if that matter is not resolved, what happens? Everyone goes to the court. Disputing, who also disputing party goes to the court. Even it is between the inter-se between the creditors, right? So this is a bilateral issue between, say, some creditors. So it can be sorted out through mediation, give and take, so that by the time the court adjudicates upon them, the insolvency process can be got over with through mediation. This is, and secondly, like I spoke about, that when a resolution plan is being prepared, the mediations can keep on taking place side by side, or when resolution plan is being discussed, the final resolution plan, the thing can be changed through mediation, so that when they reach a settlement, that settlement cannot be challenged in any court. That makes it the beauty within the insolvency process. Next I come on to is the avoidance transactions. It could be very successfully used in the avoidance transactions. Avoidant actions sometimes takes a lot of time, or till recently, when the CRP was finished, the applications were also dismissed. There was nobody to take care of the application. We are awaiting the new amendments which are going to come in, but till now we are going to deal with whatever is in the statute at this point in time. The avoidance action would help in swelling the asset pool of the debtor in a cheaper and a more time-bound manner. Many cases that we have seen that in which avoidance action, an order has come against the debtor in an avoidance action. Can anybody tell me whether they have seen something like this in last 6 to 7 years? Has it come to anybody that some matter has happened? Here is that it really happens, has happened, but yes, it is occurrence. So if we can help out the corporate debtor to come out with his interest, what his interest is and what his position is. This is where the mediation comes up and tells him, look, Mr. Debtor, if you do not agree to this, there are specific reasons and specific facts which would take you towards the penal route. So why not settle this matter now and here so that there are no actions taken thereafter. Now, on this, I would like to add one thing. In many jurisdictions, so this is a two-way, two-way thing. It can go either way, in a positive way as well as a negative way. In many jurisdictions worldwide, when a settlement on avoidance action takes place or on a resolution plan takes place, in some jurisdictions, they prohibit avoidance action. Okay. And in some jurisdictions where there is no avoidance, this sort of rule is not there, what do you think the promoter is going to ask for in a mediation? Look, I'm going to settle. So if my assets are valued at 100 rupees, now I say my assets are, I'll give you assets, another 50 rupee more assets to you, 150. But the settlement agreement should contain that there would be no avoidance action. So these sort of things, how the legislature views them, can this be a reality? Can a mediation bypass a criminal action of a person? Effectively, what you are saying is that I will tell you where my other assets are, where I have diverted my funds, but please don't let penal actions come on to me. So would that be permissible in law or not? This is something which the legislature has to look upon. Coming back to the business to consumer cases. In insolvency of an enterprise, where consumers and other similar stakeholders are involved, mediation can be used effectively to create consensus amongst the large shareholders having diverse interests to improve efficiency of decision-making process. Now, these have been used in enterprise groups, right? Where the group insolvency is there, and you need to bring those groups together, the creditors together, all the debtors together, and all the operational creditors together. So how do you go about it? This is something which is of academic interests right now, because group insolvency is not yet legislated in India. It is still in a framework stage. So this is something which would come in the future, and this is something which is going to be very important in terms of consolidation of the enterprise together as a substantive consolidation or otherwise. The last use of mediation which has happened in Lehman Brothers, Graham Lines Incorporated, and other many matters within the EU, between United States and Canada, because a lot of cross-border cases happen between Canada and US, EU and US, UK and US. So in case of cross-border and group insolvency, remediation may help resolve disputes arising from multiple insolvency proceedings. Very important because the costs are very prohibitive. Most of the times when the law firms are asked to open up a strategy on a cross-border issue or a cross-border insolvency where an asset is located in some other jurisdiction. So the main factor is vis-a-vis the cost of the recoveries from this asset, vis-a-vis the cost that would be incurred for initiating a case in that specific jurisdiction. So it has to be weighed, the pros and cons have to be weighed before even we can start something on this sort. But yes, mediation can help us out because the costs are not so prohibitive, they are less, and they can easily be cleared up through mediation. So mediation may be used until a formalized structure of group insolvency is put into place to settle disputes within an enterprise group, which might initiate a group insolvency matter. Now we will talk about two cases in insolvency which were initiated in India. There, in the Parvinder Singh versus Intech Capital Limited, I'll just read out the facts to you. Promoter filed an appeal before NCLAT against initiation of CRP of Messrs. Jagtar Singh and Sons Hydraulics Private Limited. So, appeal said that the promoters are ready to settle the claim of the financial creditor. For the same, it considered necessary they were ready to move before a mediator who shall be appointed by the appellate tribunal. So Mr. Justice Sikri was appointed the mediator in this matter, and a settlement agreement was reached. The term conditions in relief were that financial creditor shall pay a fee of IRP and other legal expenses till a certain date. As CRP is admitted, the board of directors stands suspended. So Mr. Parvinder Singh, one of the employees of the corporate debtor, was given the authority to sign the settlement agreement. And promoters gave an undertaking that they would honor the settlement agreement and all post-dated checks would be honored on presentation. Any default in payment would entitle starting of CRP under Section 7, a fresh petition. On payment of the entire amount, the financial creditor shall withdraw all petitions against the corporate debtor and return to them the post-dated security checks. But the corporate debtor could not fulfill his obligation and CRP was initiated, despite the fact that mediation was entered into. Now, there were two cases. One was Sodexo India Services Private Limited, and the other was the Mr. Harish P versus Messrs. Chemisol Additives Private Limited. Not and so in both these cases, operational creditor was an employee of the corporate debtor. He defaulted on obligation to pay the amount of rupees X. The employee, like normally employee would send a demand notice under Section 8 and then filed a Section 9 petition. NCLT in its order stated, and I'll just quote them verbatim, for an agreed party, knocking on the doors of judiciary should be the last resort. Such party should exhaust alternative remedy available by virtue of agreement they themselves have voluntarily executed, and terms and conditions in those agreements would bind them. In the instant case, approaching this adjudicating authority is not the only remedy available for the petitioner as per the terms of agreement. Terms of agreement actually spoke about mediation and arbitration. So they first said that their petitioner can also avail alternative remedy available in the agreement, which is binding on both the parties. Since the petitioner has relied upon the terms and conditions of the agreement in support of its claim, it cannot selectively choose to insist payment in terms of the agreement. So effectively told that go for mediation. So so the employee moved NCLAT. And NCLAT actually said that the terms and conditions of the agreement are separate from a default. And if a default has occurred, the NCLT is only empowered to either accept or reject the application. It cannot get into the merits of the case. So this is what was said in this matter. Again, the question was on mediation, and this is how it happened. Like Mr. Chandhiok has said that there were two parties, one from New Zealand and from some other country, and they mediated on their behalf and got the settlement agreement done. So these things have been happening internationally and within India as well. We have also done a pre-insolvency mediation between to help them not to get into the IBC way, because once a company gets into insolvency, everyone stand in a lose-lose situation. The simple reason being that the creditor would take a haircut, the debtor would lose his business probably, the employees would lose their jobs, the vendors would lose their business in terms of because the timelines are so high in IBC settlement, the CRP matters, that during those 2 to 3 years time, which normally takes for a settlement of an IBC case, the vendors would not be able to supply to that corporate debtor, and they would be losing out. So that's the basically effectively losses on all the stakeholders. So if we can cut that out and get mediation done within a pre-insolvency stage, probably nobody would have to suffer. Going on next.
So can I ask?
The good faith requirement. So when we talk about the good faith requirement, very essential in an insolvency case. If we take a case of those avoidance agreements, so if I do not have a good faith as a debtor, if I get these statutory legislative guidelines or actual law stating that avoidance action would not be initiated if you get into a settlement with all the parties, think about the number of cases that would come up for settlement. This can be a boon or this can be a bane, depending upon how we use it. With proper checks and balances and with proper statutory guidelines on this can be a game changer. Feasibility requirement. So when we are mediating upon a resolution plan, the resolution plan or the reorganization plan must be workable and reasonable. Workable in the sense that it should be based upon certain factual positions that people would be paid off in a proper way, and reasonable in the sense that it should help out all the creditors in a similar fashion. The plan must be linked to complex assessment of debtors' position, that is, the amount of debt, assets, market, business opportunity, and the changes in the market. So a future plan needs to be taken care of, how it is going to be affecting the corporate debtor in a longer run. So unless that, the plan is going to fail in mediation, because when we talk about mediation, it is a settlement between two parties. So if the creditor agrees to it and the debtor agrees to it, they have to abide by that. Otherwise, there would be a mismatch. Fair balance between debtors and creditors' interest must be established. The reorganization plan must establish a balance between continuation of the debtor's business and fast and reasonable prepayment of the debt. In many cases, you would have seen that people have been asking for 6 to 7 years to make the payments. So if it takes 5 to 6 years to make the payments, how would the business run? Or if faster payments are made, say within.
क्या
Pardon?
बात है?
Pardon?
तुम्हें क्या हो गया वो पढ़ना? उसमें क्या नाम होता है उसका लेडी का? एलिजाबेथ
Nidhi, you are on. Nidhi, your mic is on.
की जेन ऑस्टिन में है, मगर वो लड़की का नाम था
Nidhi,
एलिजाबेथ।
ज्यादा बात होगी ना
Nitin,
तो
can you
उसको
just
कह देना
मैम मैं आंखें मिल के बैठ रहा हूँ करते
डोंट गेट मी
right?
am I audible? Hello.
यस सर यू आर ऑडिबल
We are audible.
Okay, okay. Some sort of disturbance just puts me off balance. That's it, right? So we were talking about the fair balance between the debtors and creditors' interest. There must be a balance between the continuation of debtors' business and fast and reasonable repayment method. So if it is fast, the debtor might suffer. If it is late, again the debtor and the creditor both may suffer. So there has to be a balance between all these things. Protection of interest of all creditors. Now this is an issue that the new discussion paper is bringing out new controversies in terms of how the secured asset has to be treated. But leaving that aside, since it is not yet legislated, many creditors may not have participated in the mediation process because there might be many creditors, operational as well as financial. And those people who have not participated in the mediation process, they cannot be said to be kept out of the reorganization or a restructuring plan. So you should not treat the creditors differently because that is going to upset the whole cart. Even without the consent of all the creditors, the reorganization plan must ensure continuity of the debtors be able to repay the debts in future. So effectively, what we are saying is that there is a lot of scope in this. There is a lot of scope for statute to bring in different changes in the statute to help mediation process go smoothly and function well for the benefit of all the stakeholders. This way, we can actually help out the timelines and increase the value of the asset. So before we go on to the next slide, Nitin, can we take a break for 10 minutes? Nitin. Nitin, can you hear me? Okay, ladies and gentlemen, let's take a break for 10 minutes. It is 5:03. Let's convene at 5:13, 14. Is that okay?
Fine.
Okay, okay. Thank you.
Tell me.
Participants, hope all of you are back now. Rocky sir is starting his session again. He's resuming. Sir is also there.
Welcome back, everyone. So we have spoken how to use mediation in an insolvency process within the sphere of insolvency. Now let's talk about, let's get into the advantages of mediation in insolvency, and we will be also talking about challenges involved. We will be talking about how to become a mediator and what qualities of a mediator should have. All these things we'll be talking about in this session. And pardon me if we are repeating something, because these things need to be repeated so that we can understand these things. Mediation increases the likelihood of a win-win scenario and decreases the likelihood of a lose-lose situation. Like we have already discussed, that settlements are entered into between the parties on their own volition, and when they enter into an agreement, they have agreed to abide by the terms and conditions of that mediation settlement agreement. And once they've decided to abide by those terms and conditions, that means they have given their acceptance to that terms and conditions. So it is a win-win for both the parties. Ultimate resolution of the total dispute is not the main goal. Like I said, if we could settle in a process of insolvency 10 out of 10 disputes, we can settle 4 or 5. Rest can be adjudicated by the adjudicating authority. However, that would help them to decrease the timelines of their adjudicating process and help the insolvency process by retaining the value in the asset and use of the assets of the debtor. ADR preserves the normal relationship between the parties. Process is very flexible. The mediator and the parties can create their own procedures and not bound by the procedures which are actually taken care of in the code, which are say civil procedure code or a criminal procedure code. Again, it saves on cost, it's confident. Another thing that is related to a pre-insolvency mediation is that during an insolvency, there are a lot of stigma involved with the insolvency. The goodwill goes away. The employees leave, go for greener pastures. The vendor stops supplying goods because they feel they would not be paid back. Or if the company is getting insolvent or gets into insolvency, they'll have to file their claims and be denied their remuneration or the cost of the goods that they have supplied. But when we talk about a pre-insolvency mediation, none of these are applicable. Nobody knows about it. Only probably the bank of the debtor and the debtor, they get into a negotiation through mediation. And only these people are in knowledge of the fact that something is going on between, some sort of negotiation is going on between these two people, the debtor and the creditor. So once that happens, the stigma is not there. They can proceed in total confidentiality and without anybody knowing what's happening within the company. And the company goes on like it was going on before. Nobody knows, nobody's any wiser about what's happened. And that makes a perfect sense for a business to keep on as a going concern without a loss in any of its goodwill or any of its customer or any of its vendors. So we speak about pre-insolvency mediation. We are using this tool of mediation to manage corporate distress. And if we can effectively use this tool as a corporate distress mechanism, like it is being done in Japan, France, in Thailand, and many other countries, then what we can look at is a lesser level of insolvencies, lesser level of court filings, and that in turn would eventually convert into lesser liquidations. More the liquidations, the more the loss of business, the more of loss of income, which directly affects the GDP of a country. In India, what we have seen is that over 60% of things terminate into a liquidation, which is bad for the economy. So to decrease that amount, we need to decrease the filings. Once we decrease that through mediation, the going concern concept would be taking over the liquidation. There would be more going concerns rather than liquidation, whatever company or a business is getting into distress. So it would effectively, the mediation would effectively become a managing tool for corporate distress. And the government should bring this tool handy for managing corporate distress. Now, what are the challenges of mediation in insolvency? We are on the cusp of a revolution wherein if mediation is brought into insolvency, in its present stage, pre-insolvency, mediation in pre-insolvency is a complete 100% can be done. Within the insolvency, there might be some hitches because of court procedures, because it has not been ingrained into the IBC as such, so, and a lot of other issues. So we'll be now discussing what are those issues, how can they be overcome. When we talk about filings and not corporate debtors, and corporate debtors could also be very small. It need not be that they could be a multi-million or multi-billion dollar company, they could be small. Most of them do not have the right business culture and the skills to conduct successful negotiations. So if you ask a debtor who is not communicating with his bank, he is effectively not negotiating with the financial creditor. He's afraid to negotiate with the financial creditor because he thinks that they would negotiate, the banks or the financial creditor would negotiate from a position of power because they have already gotten into some sort of an agreement wherein they have an upper hand. At this point in time, communications breaks down because of this specific reason. And they're not able to behave, the promoters are not able to behave rationally. As a result, they act upon those irrational and negative emotions. Communication breaks down and this happens. So to correct that, mediation is an effective process to start communication, because probably debtor and creditor would not trust each other. And if they do not trust each other, there would be no negotiation. Neutral or a third party mediator to be brought in to create that trust and to create an environment of successful communicating each other's issues and interests so that they could reach a mutually agreed settlement. This challenge of stigma that I spoke about earlier, stigma is omnipresent in all jurisdictions, be it United States or Japan or Thailand or Australia, Canada, South Africa, any jurisdiction you talk about, there is a stigma attached with it, specifically with the insolvency. Pre-insolvency mediation, like I said, can be done in confidentiality, and nobody is going to be any wiser about what's going on between the debtor and the creditor, because if we are talking about mediation, we are talking about confidentiality, and the confidentiality helps for the stigma not to get into that corporate debtors side. So nobody would be any wiser, everything can go on smoothly, and if there is this mutually agreed settlement, nobody is going to know about it because that agreement is in itself is confidential. One thing that we have seen is that mediation is basically a bilateral process wherein there might be one creditor, one debtor. The process would work very smoothly. What happens if there are multi-creditors? How the mediation helps there? Everybody would have heard about the Ayodhya dispute. right? There were many stakeholders in that, many people, and there was community mediation in that. So community mediation is a part of mediation where it happens where there are a lot of stakeholders involved. It's not a bilateral issue between two parties. It could be 100 parties, and that could also be settled through mediation. Now, what are the challenges within the multi-party negotiations? They may be particularly burdensome for debtors because of presence of many creditors involved. So debtor is one, creditors may be many. So debtors has to be present in each and every mediation. Creditors may not always be prepared to cooperate. Some may not. So this would create a uncertainty between what's going to happen. Then there might be creditors with opposing interest, and how they are going to be managed, coordinated through a mediation process is also a potential challenge. When we talk about confidentiality in the in the mediation process between bilateral parties, it could take place. But when we're talking about insolvency, so imagine a case where a debtor and a creditor have come together, and there is trust between the parties, and they are ready to mediate between themselves. And because of debtor's naiveness, he discloses some confidential information to the creditors. And the creditor walks away from the mediation. No settlement agreement has been reached. What is going to happen to the information, the confidential information that has been provided by the debtor to the creditor? That issue needs to be addressed. Whether it can be used by the creditor to initiate insolvency or not, that issue has to be taken care of. Voluntary versus court mandated mediation. We have already spoken about it. Just Lord Phillips stating that you can take a horse to the water, but you can't make him drink. And in the next line says, even the horse to drink that water. You may like it or you may not like it, but he will drink it because you're taken to the water. So yes, court mediation is essential because it was mediation people which would circulate word of mouth by people who would understand the ethics of mediation and spread this message about mediation, and the people's mindset would change regarding mediation. In pre-insolvency or a pre-default situation, creditors might be very rigid in their approval procedures. If anybody would have negotiated with the bank, or if you have met bankers in a COC, they all come back to tell you we have an approval from our authority. Permission or approval doesn't come for days. Even the voting has to be suspended sometimes on the agendas because their permission or approval hasn't come in. That is an issue everywhere. If the timelines have to be, the people who can take decisions need to be present at the COC, not the people who are only authorized to appear before the COC, not take the decision. So this is again going to be an issue within the mediation framework. So when a company is close to being an insolvent, like default,
Sir, you are not audible.
am I audible now?
Right now it is okay, sir.
Okay. So when the company is close to being insolvent, the default has happened, 90 days have elapsed, NP has been declared. At that point in time, would a creditor settle with a creditor? Or sorry, settle with a debtor? Now, this is an issue of a mindset of a creditor. Tell me one thing. How many of you would like to settle at this stage? How many of you, as an IPs, would like to settle at this stage?
Sir, first whether IP can mediate in the process, because this may be he may be interested, he may be charged for misconduct, something.
No, I'm just talking as an IP, not as an IP of that specific matter, but as an insolvency professional with the outlook of an insolvency professional. What would you do in these circumstances if you are advising that debtor or a creditor?
It is
Just tell
always
me.
to advise the mediation. It is always to advise the settlement.
Yes, but would the creditor settle? Because their mindset are such that if we settle at this point, just tell me one thing. If I am nearing a default, okay, and I go to a bank and tell them, sir, I am nearing a default. Would you settle my loan at 90% or 95% of the loan amount? Would they do that?
No.
Sir, it's a business opportunity to the creditor, because he has to do the business. So he has to give a chance to debtor so that his business also will grow. Maybe
Exactly. But the point here is that
bank will not listen, no? Bank will not
banks
listen.
also, sir. Banks also, that for that purpose only one-time settlement, all these things have come, no?
See, one-time settlement is fine. If I tell them default has not happened yet, right? Most of the bankers, I'm not talking about a specific case, but most of the bankers have told clients, come to us when you have defaulted. Right? We don't want to talk to you now. This is the mindset of a banker. Now tell me if there is an impact assessment done at this point in time. So if debtor is willing to pay back his 95%, there would be a haircut of 5%. And thereafter, when it gets into an insolvency situation, 6 months have elapsed, and there is going to be a haircut at the resolution plan stage. There is going to be a haircut of almost, say, 50%, right? The banker is ready to accept that 50%, but he's not ready to accept that 5% that could have settled before the default happens or immediately after the default happened. Now, what we're talking about is public money. So banker is now not decreasing his losses. He's increasing his losses just by going into insolvency. And that is the mindset we need to change. 5% at a pre-default stage, 50% in a resolution plan. What makes a better sense?
But that vision has to be there, no?
That is what I'm saying. The mindset needs to be changed. They need to be, and bankers need to be asked, if an impact assessment is done on the assets of the debtor, what would have yielded at the default stage, or what they would have yielded at a resolution plan stage. The difference, who's going to pay for that? Somebody has to be responsible for the loss in that asset value. So this is one thing that needs to be, the mindset needs to change on this. Some sort of a system has to be put in place to take care of this mindset. Sorry, this situation. Then there are issues related to effective efficacy of out-of-court agreements, as in case of ex post avoidance actions that we have already spoken about. That in case you give them a total amnesty from avoidance action, mind you, they would be out of 100 insolvency filing, 50 or 60 would be coming to you immediately for a settlement. Ki paisa hata, I mean, people who have siphoned out money, that would be a big boon for them. Financial institutions are bound by statutory guidelines for RBI for restructuring. So these restructuring guidelines under June 7 circular also needs to be tweaked to make them in consonance with faster adjudication of disputes pre-insolvency and post-insolvency, and giving those rights and the powers to the bankers to do so without any issues regarding their honesty, their capability, their good faith. They should be able to do that so that public money can be saved. The next thing that we are looking at is how a mediation process would be configured in the context of insolvency. At the present time, if we talk about pre-insolvency situations, what are the options available to a debtor or a creditor to get into a pre-insolvency settlement? Either it would be through a pre-pack, or it could be through Section 230 Companies Act scheme of arrangement. It could be through the June 7 RBI circular, right? So in all these cases, or it could be a one-time settlement. Mostly in all these cases, the creditors need to initiate a process. So who would initiate a mediation process? Very importantly, that process should be initiated by any of the stakeholders, the debtor, the creditor, or by both. So this is something which needs to be very, very clarified, that who is going to initiate that. The next is the identity of the mediator, whether it is going to be NCLT who is going to appoint a mediator, or NCLT will mediate, but we are talking about pre-insolvency mediator. So if I say X, individual X, and you say individual Y, so can two mediators be appointed, and how the work would be done? So that needs to be clarified. Then there's the question of private authorities and public authorities. The new bill that is coming in would give some foothold to private ad hoc mediation centers to come up and to provide mediation services. Then we are talking about the enforcement of mediation agreements reached with certain creditors. Now, think in this way: there are three creditors, right? And out of those, two creditors enjoy 70% in between them of the voting total asset value of the voting rights. The debtor settles with these two creditors, and the third creditor takes the debtor to the NCLT with a Section 7 filing. What will happen to the mediation agreement? Can that mediation agreement bind the third creditor? Importantly, we have to understand the ramification of this. So till the time there is one debtor or two, one debtor and one creditor, or one debtor and two creditors, one debtor and three creditors, and if every mediation is done with everyone and everyone agrees, I think there could be a win-win situation. But again, coming back to one of my favorite talk is that India has 6.3 crores of MSMEs. Okay. Out of the 6.3 crores, 30 lakhs are almost equivalent to corporate debtors, that is legal entities. Out of 6.3 crores, 0.3 crores are legal entities. 6 crores are either individual or normal partnership firms. IBC caters to 0.3, the 30 lakh corporate entities. What happens to the 6 crore MSME entities who are without any statutory provision to exit, except the old Prudential or the Presidential Insolvency Act? Beyond that, there is nothing, right? So those 6 crore MSMEs are not legislated as far as insolvency is concerned. So pre-insolvency is the big option. And one stat I'm going to give you is that almost 25 and 30,000 cases have been filed till date. Whether they were settled or CRP is going on or liquidation happened, we're not talking about that, but the number of filing that we're talking about. It is 1% of total 30 lakhs is 30,000 on an average. So what would be 1% of 6? That is 6 lakhs. Go by that yardstick, that 1% of the total entities could go into insolvency. So we're talking about 6 lakhs of MSME over a period of next 5 years, if the individual insolvency comes in. And most of these crore MSMEs who are partnership or proprietorship concerns, majority of them would only have one creditor. Okay. And if there is only one creditor or two creditors at the max, we're talking about the final creditor, the effectiveness of mediation goes up hundreds of folds. This is where mediation can be really, really effective. So what we should do is that we are looking at 6 lakhs of cases and 6 lakhs of mediations over a period of 5 years or 6 years. That would make 1 lakh mediations up, right? On I'm talking about potentiality of the argument that I'm giving. So 1 lakh mediations, if they happen in 1 year, and if we have 10,000 mediators, which is a huge number I'm talking about. So if we have 40 IPs and all of 4,200 IPs become mediators, imagine the amount of work which would be available to all of you. Just think on those lines. Cases, 2,000 mediators, insolvency mediators, add on another 3,000 from other mediators who would learn insolvency, 5,000. That means on an average 20 cases for every mediator. Mediator can't do in these cases because the timelines involved. It is not like insolvency CRP timeline. It is, I mean, nobody is going to hold on to a mediation process unless it is short and sweet, right? So five hearings, 4 hearings on the mediation at the max. Little complex, probably you can have another couple of more hearings. That's it. So this is one thing that you should think about. The French model has been proven to be the most efficient in pre-insolvency. The French legal system of mandataire ad hoc, and there are 2-3 words which is in French. I can't pronounce them, but reglement, amiable, conciliation, and out-of-court workout is typically initiated by debtor on a voluntary basis. It often involves the intervention of a third. Third means the mediator or a neutral. Considering the Indian situation, there are no provisions for the involvement of mediators in restructuring and insolvency provision, may be only exerted by a code mandated mediation. So what we're looking at is that somehow some sort of rule, some sort of regulation, such sort of statute or a legislation within IBC should be enacted to help these things, help in mediation, the processes to help in mediation, so that the adjudication process, the companies into insolvency, post pre-insolvency mediation to be initiated on something on those lines should be put into the legislation so that it helps MSMEs to not to get into insolvency. Do not have means, they do not have asset base. Where will they pay their fees from of IPs or anything? Even the creditors would say, I don't want to get into insolvency mode because we do not have assets to cover the expense of an insolvency. So these things kept in mind should be made essential, special processes to be implemented so to help MSMEs get out of these situations. The qualities of a mediator. Empathetic. What is empathy? Can anybody explain to me what is empathy? Empathy is somewhat, not, I would not say opposite, but somewhat different than sympathy. Now, anybody can explain what is empathy? Okay, what is sympathy? Let's talk about sympathy. So if your friend has lost his father, probably you will go to him and share your feelings with him that, okay, we are sorry you have lost your father. I am in this special, in this time of agony or distress, we are with you. That is what you are going to tell him. So that is sympathy. Empathy is the ability to emotionally understand what other people feel. So if a friend of mine has lost a pet, and I understand because I too probably lost a pet at certain point in time, that would be empathy, but that need not be shared also. It is essentially putting yourself in someone else's position and feeling what they are feeling. That is empathy. So the mediator has to be empathetic. He needs to understand what the debtor is feeling in terms of mediation in insolvency, and what the creditor is feeling in terms of insolvency. I'm not talking about anything other than a mediation in insolvency. Probably if it is a family matter, so what husband might be thinking or what wife might be thinking. In case of insolvency, it is between debtor and creditor, the mediation. The debtor, what debtor is going through or what creditor, he should be understandably knowledgeable enough to understand what he is going. Very importantly, he should be non-judgmental. So the other day there was a client. So one of my juniors asks me, what do you think of this client? So I asked him, what do you mean by this? He said something which he disclosed to you. Don't you think he's not a right client? I'm not going to judge a person just because what he is telling me. There might be extenuating circumstances for him to do something. You would never judge a person. You judge a person when there is evidence that he has done a wrong thing. But then again, if they tell you about those wrong things, you're not there to judge. You're just there to run a process. The mediator runs a process. He doesn't sit in and decides the settlement agreement. He just runs a process. He cannot be judgmental. You will have to have patience and persistence to understand a client, to be empathic with me, and to show the empathy to him, understand what he is going through, and take your call on how to communicate to bring out the actual interest of those people, so that you understand the interests of both the parties and have that acumen to match those interests and get them to a solution. You have to be very optimistic. You have to create trust between the parties. You have to make the parties trust you. You have to be sharp-minded and creative. You have to be probing skill to extract communication, information, data from the disputants who are in front of you. And like they say, common sense is not very common. You need to have that and a good sense of humor as well, because it can be very depressing to hear a lot of negative things, and mostly negative when it comes to IPs or mediator. How to become a mediator? So if you want to become a mediator, it's very easy. You go through a 40 hours training. 40 hours training is conducted by Maadhyam as well, where Mr. Chandhiok can help us out. And thereafter, you need to have 10 sit into 10 mediation, no, sit into 20, at least 20 mediation. And out of those 20, you need to have 10 successful mediation. And then you can be accredited as a qualified mediator. You would be accredited as a mediator after you have taken that 40-hour training, but you need to also go through some mediation to become qualified mediator. Now we'll take, the time is also getting close to 6. So let's take some question and answers now. Let's have a Q&A session. Anyone, any questions?
Sir, I understand now that IP cannot directly act as mediator, but he has to undergo this training.
Yeah. The training, see, like you became an IP, what did you do? You went through a 50-hour training module, right? You passed a test, then went through a 50-hour training module, and thereafter you became an IP. Similarly, a mediator has to go through a 40-hour training. And after that, going through that 40-hour training, he has to start mediations and do some mediations, 20 odd mediations, and then be successful in 10 and then become a qualified mediator. That would actually put you a stamp on you that yes, you can, initially you need to mediate with another mediator as a co-mediator, and thereafter you would be given individual cases to mediate after you have done yours 20 or 10 odd mediation, successful mediation. Thereafter you will be given put up as a single mediator. Probably if Mr. Chandhiok is here, he can put more light on this. Chandhiok साहब आप हैं कि I think he has left. Anyway, any more questions?
Who is sir?
In ongoing case, in that case, if I am an IP, I cannot do the mediation.
No, come again. I didn't get you properly.
If there is a CRP process or a liquidation is going on, CRP process going on, I am an insolvency professional. I cannot do the mediation in that case. No?
See, when you are talking about mediation, see, if you talk about me, I was doing one CRP. I was an IP, and as an IP, there was some people who were fighting in a COC, 2 creditors fighting in a COC. So my job was not as a mediator per se, but as an IP, used my mediation skills to make those 2 creditors come to some sort of a mutually understandable solution, right? So that helps us out without getting into an actual mediation. Say for example, your family has some dispute and you just help the parties come to a agreeable solution. So you're not a mediator, but as a normal human being, you have decided something and settled the matter of 2 disputing parties, right? That is something which you have done as a human being. Similarly, what I did in that COC was simply being a human being as an IP, sorted out those differences. But as a mediator, if you want to be a qualified mediator and then settle disputes, then as an IP, you can do it without saying it as a mediation. But if you want to do as a proper mediation, then you need to be a proper mediator, qualified, certified, accredited, and then that.
But only you cannot claim any fees, no, then?
No, sir, this is totally within the scope of your being in that CRP. You cannot claim any fees for settling any disputes between parties who are at dispute, because that is your job, sir.
Sir, I have two related questions.
Yes.
Firstly, where can one do this training? And does he have to go with an already registered mediator? And secondly, whether a specific qualification required before going
There
to
is no qualification required to be mediator except a person having one thing which is rarity, right? And what is that? Tell me. Common sense, right? If you have common sense, you can sit in that.
Yes.
Sit in that 40 hours training program, right? It's nothing but common sense. Nothing.
Yeah.
Little bit of no law involved in this. Nothing is involved in this.
And the training program is provided by whom?
Program is provided by Maadhyam. It is provided by Delhi High Court. It is provided by Supreme Court of India. So, like Mr. Chandhiok was saying, is conducting mediation training programs. So, if you want, you can get in touch with me on this number. We will put you in touch with mediation with Maadhyam. They can help you out in that. Earlier, IICA was conducting, but IICA is not doing it right now. For last almost 7-8 months, they're not doing it. So, but this is something which you can do, and then there is after doing this, then there is a second qualification, the advanced mediation program as well, which you can do.
Okay, then I have got your number. I'll talk to you regarding this.
Sure, definitely.
Sir, is this 40 hours training program as a part of ADR rules, or is there any rules or act which says that we should have this?
This is, ma'am, this is the internationally recognized what you call this specialization program on mediations, that they internationally they ask for a 40 hours mediation trainings. I think there's some convention on it in UN which states that. So every country is conducting 40 hours mediations. Every country.
I think Mr. Chandhiok has joined us.
I was always there, Ji. Not that I've joined. I was always
Any
there.
questions?
Listening to Mr. Rocky all this while, adding to my knowledge.
You are there. Sorry, I was. People are asking about when Maadhyam is going to conduct.
2 hours, including your 10 minutes break.
Okay. So, sir, you will have to answer that question, sir. When can people contact and where can people contact?
They can contact. You can share my number to them. They can contact.
Okay, sir. Yes, sir. I will do that, sir.
There's no difficulty at all. We'll do it. There's no difficulty.
Yes. So if we can have Mr. Chandhiok's number and email ID, please. So
yes.
Yeah, we will do that. We will do that. We'll send it to Nitin, and Nitin will forward it to everybody.
Forward it to everybody. There's no problem.
Sure, sir. Sure, sir.
Thank you, everybody. Thank you so much. Thank you, Nitin.
Thank you.
Sir,
Right, sir.
one more query, sir. Can I?
Yes, ma'am.
Please.
The turnaround profession which you were referring to in other session.
Yes, sir.
Is also, I mean, is mediation part of this turnaround profession?
Ma'am, pre-insolvency, it can become a part and parcel of turnaround as well.
Sir, still it's not clear. You mean to say that both are different profession?
Both are different.
Pre-insolvency, it can be part of it.
Ma'am, mediation is a tool which can be used in a turnaround situation as well as a post-insolvency situation. Tool to fasten the dispute redressal or to fasten the settlement between a debtor and a creditor in a pre-insolvency situation. So it's simply a tool. And if you become a mediator, you become a tool a person who can use that tool to settle differences between any person, be it in a family matter or in an insolvency situation.
Participants, any further question from your end?
When we say that mediation can either be voluntary or court ordered, unless it is voluntary or unless it is court ordered, how can we get the assignments? I mean, how can we make people aware that, okay, we are also here to do the mediation?
So, yes. So, sir, would you answer this question or
Yes,
should I
I'll
answer?
answer it. I'll answer it. I'll answer.
Yes, sir.
Sundarji, the position is this: when you are in a pre-default mediation, then the mediators actually amounts to a award within the meaning of Arbitration and Conciliation Act Part 3. So it becomes a conciliation award. When it's a conciliation award in law, it has the approval of a decree of a court. So in a pre-default mediation, when you're not before the NCLT or the adjudicating authority, you would file that mediation settlement as a award in terms of Part 3 of the Arbitration and Conciliation Act 1996. The mediator will make that award. Though it's a mediation settlement, it's a consent award. Let me put it this way. And that award in law has a recognition of a decree for people to obey. And if you don't obey, you will have a right to go get it enforced in court of law. That's the position in law. And then if you are post insolvency or CRP process, in any case, you can go back to the NCLT to get that recorded, and that becomes enforceable. But the mediation bill is in process. We expect probably the next session we'll have it. Once that bill comes in and becomes the law, then within the mediation settlement, that law says that the mediation settlement outside the court by a recognized mediator would be treated as binding between the parties and enforceable in law. That's the third aspect.
Sir, I have a small query regarding this. So, is it to be made a rule of the court,
no,
just
no.
like the arbitration of?
See, under the 1940 Act, you had to make it a rule of the court, and then it became a decree. Now you don't have to do that. When you get a consent award, it means that award is a decree in itself. And if somebody was to disobey that, then that the award becomes enforceable in law. So you don't need to go to court at all. If it's outside the pre-default. So the mediator will actually pass a consent award within the meaning of Chapter 3 of 1996 Act, which does not require anything from the court at all. No stamp, nothing.
Correct, sir.
So let's, any more questions or should we wrap up, Nitin?
Sir, one more.
Yes, Mr. Trivedi.
Yeah, I just wanted to add, sir, the Institute of Chartered Accountants, Institutes of Company Secretaries, as well as Institutes of Cost Accountants have also been allowed as per the, I think, 2019 amendment to act as a mediator or as an ADR professional. And the Institute is conducting a lot of programs and we are certifying ourselves for that. But what are the opportunities, sir? When we, I mean, after that, what we find is that, again, we have to, I think, approach to the same panel of High Court or, the panels which are there to enlist ourselves. Am I right, sir? Because I'm also certified ADR of ICA.
No, I want to clarify to you, Mr. Trivedi. You don't have to approach anybody unless you want to go on their panel.
Yeah. Yes, sir.
But there are instances, for example, with me today, I don't go to, I may be a recognized mediator is a different question. I may be getting directly from the court. But for example, which I gave you an example of transferred undertaking that I said in the beginning.
Yes.
People came directly to me and I passed an award. And that's the end of the matter. So today the scope is, yes, it is evolving. If you see other parts of the world, mediation is outside the court annexed mediation. We did not get that recognition right away. The reason was this, that here people give much more respect to something coming from the court. And that was the reason that we started a court annexed mediation. And then we started now court annexed arbitration. However, today, the institutionalization institutions are coming up, and that's why I said that once the Mediation Act comes into play, then you don't need to go anywhere. Even now, you don't need to go anywhere. Two parties can approach you. You will write the document as a conciliation document, which will empower you to act as a mediator and therefore record their consent and proceed. That's all. You don't need to go to anybody.
That's nice. And I think I just want to add, you rightly said that IRP or RP, I mean, he is also a mediator because most of the time he has to deal with the claims process, he has to deal with the
Necessary
COC.
for him. You
Practically,
are right, Mr. Trivedi.
practically he
Change
does
in
that.
his profession to bring change for his negotiation, for a change to communicate with people. It is necessary that he must go undergo the training. That's the point
Yes,
I made.
yes, you're right, sir. 100%.
Even if you don't want to be a mediator, yet it will change your professional life,
Yes,
how to deal with people, to understand the concepts of negotiation and communication better.
the outlook itself changes.
That's
I
right.
observe.
You're
The
right.
outlook, the manner in which you look at things also changes, and they also
That's
start
right.
appreciating that this is a person who is trying to just help us out rather than
That's right.
the legal
That's right.
process which is there.
You're right. Absolutely right.
Appreciate. Thank you, sir. Thank you, sir.
So let's, Mr. Rocky, wind it up now.
Yes, sir, we should do that. It's all, we are over 5 minutes over the time.
Yes.
Thank you, sir. Thank you, Chandhiok sir, and thank you.
Everybody, thank you, everyone. God bless you all.
Thank you very much, sir.
Have a great evening.
Thank you, sir.